In this video, we're going to be looking at an evaluation essay on causation in criminal law. This question could come up on exam 3. Exam 3 is where you will be answering 3 essays, one on criminal, one on contract, one on tort. So this is a question that you could be asked in criminal law, and the question is, discuss the problems that exist in proving causation. And it's worth 25 marks, and you would have 45 minutes in the exam to answer it. The reason I've got a picture of drugs here at the top of my document is to remind you that in this essay, whilst we do want all the rules and cases on causation, it's very important that you are evaluating the problems with the law. And one of the big problems with the law on causation is whether the victim has broken the chain of causation when they self-inject drugs that the defendant has given to them. And that's an issue we'll come back to a bit later on. Remember that your AO1 marks are worth 10, your AO2 marks are worth 15. So you do need to make sure that you are putting plenty of an evaluation and analysis in the essay. So if we scroll down to my suggested answer, as usual, my AO1 comments are in black, my AO2 comments are in red. So you need to start off with the definition of what causation is. And of course, it's proving that the defendant caused the consequence, and that is essential in result crimes such as murder. Straight away, I've evaluated and said that some people say causation is more about attributing who should be at blame here, rather than looking strictly at objective factual proof. I'm then going to go into my rules. So in order to prove causation, we need factual and legal causation, and I'm going to start with the factual stage. So factual causation uses the but-for test, and it was met in Paget because she never would have died but for being used as a shield, but in White it was not met because the victim would have died anyway. I've said what the cases are, and I want to evaluate them. So the case in White is fair because although what the defendant did was obviously wrong, he was not the cause of death. She was going to die anyway. He did, of course, get prosecuted for attempted murder. In Paget, you could argue that perhaps the case is a little unfair because clearly the defendant didn't expect the police to return fire. I mean, that's the whole reason he used her as a shield. So you could argue it does seem a little bit unfair on the defendant where he didn't foresee the consequences. I'm then going to move on to my legal causation. So the first stage in legal causation is the de minimis rule, which says that minimal causes may be discounted, and I've got Kimsey there and my slight or trifling link. My evaluation of Kimsey is that this slight or trifling link is a very vague question for the jury. Might result in inconsistent decisions because whether the jury think that the defendant was more than a slight or trifling link might depend on who's sitting on your jury on any given day. Next rule for legal causation is your thin skull rule, where you take your victim as you find them, as in the case of Blau. Now, in terms of evaluating Blau, it could be said that the defendant should not be liable for her death because she did choose not to take that blood that she required. And he could have been charged with the lesser crime of wounding with intent, and he still could have got life in prison for that. However, and the argument I certainly favour, is that the defendant should be liable because it was the stab wound that caused her death, and she is fully entitled as an autonomous being to refuse treatment. But of course, you could argue both sides of the coin here. My next stage in legal causation is the fact that the chain can be broken by a novus actus interveniens or a new intervening act, and I've listed my 3 types there. And I'm going to start off with my third-party cases. And straight away I've made the point that public policy comes into play here because the courts are reluctant to allow doctors to break the chain of causation. We don't want doctors to be worried about being prosecuted, and we also want to make sure that the defendant who has done something awful, such as a stabbing or a shooting perhaps, so that they are responsible for their crimes. So I've given what the general rule is. You'll notice that I'm using very important points from the case. So in the case of Smith, thoroughly bad, 75%. In the case of Jordan, I've used the phrase palpably wrong. I could perhaps have put potent in causing death here for Cheshire, couldn't I? So you'll see there from the amount of black that is written that the facts that I'm giving about these medical cases are very short. Okay, I want to concentrate on my AO2. So I've shown that I know the ratios and I want to say whether they're fair or not. So you could argue cases of Smith and Cheshire seem a bit unfair because the issues that happened, for instance, in Smith, the treatment was thoroughly bad. It did reduce chances by 75%, which is huge. So that does seem a little unfair, perhaps, and quite extreme that even when we switch off life support, that won't break the chain. However, rationale for that, and this is my evaluation, that the doctors are not strictly ending their life. They're rather allowing the initial injury, the stabbing or the shooting, to take its natural course. I've pointed out that they can break the chain if palpably wrong, but of course the problem with that is that we don't know how bad treatment has to be in order to be classed as palpably wrong. So there needs to be some clearer rules really on that. I've then gone on to consider when my victims can break the chain, so victim's own act. Again, you can see my black, my AO1 is short. I'm citing my cases, but I'm not writing lots and lots about them, and that's important here. So my evaluation of these cases, the fact that it'll break it if daft, it won't if reasonable, that it might be unfair to allow the jury to decide that. Because in the case of Williams and Davies, the jury felt that what the victim did was daft. However, they weren't in the victim's position, and clearly the victim was frightened. So that seems a little unfair, perhaps. But the big problem that I mentioned earlier in causation is actually about, does the victim break the chain of causation if the defendant supplies him with drugs and then he injects himself? So really important case of Kennedy confirmed earlier cases of Dolby and Diaz and said that in general, if a victim self-injects drugs, even though the defendant was wrong for giving him the drugs, that is a nervus actus interveniens which breaks the chain of causation. The defendant's no longer liable because the victim has taken that voluntary choice to inject the drugs. In the case of Evans, though, we had a situation where the defendant supplied his own sister with drugs. The sister self-injected and overdosed in front of the defendant. And the defendant was worried about calling an ambulance, so they didn't, and unfortunately the sister passed away. Now in that case, the defendant was liable for manslaughter because although the sister had broken the chain of causation for murder, he was guilty of manslaughter through failing to summon help. So this illustrates really how complicated the law on causation and drugs are. Some people argue, as I've put there for my AO2, that Kennedy and Diaz are inconsistent. An academic called Cherkasy disagreed with the decision in Kennedy and said that the defendant still took part in the acts. So the defendant had supplied the drugs, the defendant in Kennedy had also helped prepare the drugs. So really, the defendant was part of the death. So certainly the law on causation as it relates to drugs needs to be addressed. And there you go, Reid, a little quote from Reid there, that the court seemed to be more concerned about moral fault rather than strict legal principle. Very little to say about natural but unpredictable events because we don't have any cases on it. However, in theory, it seems like a fair enough rule. I've concluded there by saying that the law on causation is inconsistent, and that we need clearer rules on this. Underneath my answer, I've put the mark scheme that we're used to seeing. So remember, your AO1 will be banded here, your AO2 will be banded here, and they'll add the two together to give you a mark out of 25. So you want to show excellent knowledge of your cases, but also excellent analysis and evaluation. So if we just scroll back through my essay, you can see that I have mentioned all of my key cases, I've got all of my ratios in there, and I've also got a lot of evaluation and analysis. And that's what we're aiming for in these essays. You've got to be very careful not to just write out everything you know about causation. You won't get full marks doing that. You'll get 10 marks. You must say what the law is and evaluate. Okay.